Everyone to my etymology class at Temple University Pan-African Study Community Education Program. Today is October 17, 2016. I have a dynamic speaker who's been coming in since 2009, all right, to my etymology class. So we're going, today's topic is juridical linguistics against connotative linguistics. Incarceration. Juridical linguistics against connotative incarceration. All right, so without further ado, I'll present to you our guest speaker for the day, Commander U. Bay.
This is an interesting title and topic that we're going to be discussing today, because what's going on is that we are facing what you call is a judicial system, all right? And so that judicial system, to give you an idea what I'm talking about, because we all have been faced with it one way or the other, and for those who have not been faced, and maybe sooner or later you will be faced. You know, you have the family, the traffic, the criminal, the civil, bankruptcy, right? And so forth. It could be more. I'm just giving you an example of what we can possibly face today. All right? And one can fall in any one of these categories. And I'm sure that we all here are familiar with what I'm talking about, what I wrote on the board. One of the main problems that we have in today is be able to persevere in the judicial system, because the judicial system is ran by these guys. Please take notes. These are the three words that you're familiar with. If you're not familiar with it, you should be familiar with it. Attorneys, lawyers, and esquires. These guys here are running the system here. Are they supposed to be running the system? No, they're not. Because the Constitution of the United States prohibits attorneys, lawyers, and esquires in the system. All right? And of course, these two follow this one here, because this esquire is below gentleman, but above a knight. And this deals with the crown. All right? You following me? You with me, y'all?
Yes.
Yeah.
I don't know if I'm losing any of y'all.
No.
Yes. Ask questions now. All right? Because I'm going to be lecturing this information. Feel free at any given time. I don't want to keep flowing and I'm losing y'all. So I want to stay with y'all with information that you need to see. Yes.
What term does barrister go? Is that just another term for an attorney or a lawyer?
Yes, that's true. Thank you. This is what I'm saying, because you need to know this. Because tonight, if anybody's not paying attention to the title, it's called Juridical Linguistics Against Connotative Incarceration. And what that means is that we have to develop, right, our own adjudicatory way of defending ourselves in this judicial system without an attorney, lawyers, or esquires, because these are the guys, I would say 95% of the time, support the judicial system. You're going to get a few who may work with you. That's just a handful. So I prefer to say 95, Because only 5% you're gonna find, and that's hard to find that 5% out of the 95 because the majority of them supports the judicial system. All right? The corpus juris secundum, this means body, this means law, and this means second. Latin word, secundum. Secondary, right? Or it can mean secular. It doesn't necessarily mean it has to be secondary, but it can also mean secular. Secular is another Latin word meaning world. Because what happens is you have, put it this way so you can get a clear picture of what I'm coming from. Criminal law comes from civil law, and civil law comes from ecclesiastical law. I'll say it again. Criminal law comes from civil law, and civil law comes from ecclesiastical law. So what I'm saying here tonight, there are 3 different levels of law. I have to give you the basic foundation so we can have this dialogue. If I don't give you the precepts and concepts of what's going on in this judicial system, you're not gonna have no idea of what's going on. So I have to break it down in a content where you'll see the foundation of where this is at. So it could either mean secular, which means man's law as opposed to quote unquote God's law. All right? This is what this can mean, right? Which is technically a second body of law to the divine law. All right? Corpus means body, juris means law, it also means right. So it's important to realize this. Why? Because what they did is they, excuse me for the preposition, the High Council, right, or the Senate or the Congressional or the legislators created this system in order for these guys to take over this. And you say, what are you talking about? Let me give you an example. Under the corpus juris secundum, and you can Google this, because we got technology today, so you can check me on it. Volume 7, Section 4. And what this talks about is they're telling you that an attorney or lawyer or an esquire is what they call an officer of the court. That's what the corpus juris secundum allows them to do, is to infringe and run the court system against the people. This is what the secundum did, that law did. Why? Because the Constitution forbids attorney. Because when you go into the Constitution, it says in Article 1, Section 9 that they can be no what? Titles of nobility. They can't take into trust, receive any emoluments, which is some form of compensation, from any foreign power. All right? This is what they cannot do. They did that to protect because this is the first delegation of authority. Because if I was to ask anybody in the classroom, what is the first delegation of authority? There's 3 branches in the Constitution. You got the executive, which is Barack is the president of. You have the legislature, and you have the judicial. One executes the law, which is the executive. One writes the law, which is the legislation, and one tries the law or interprets the law, which is the judicial body. All right? And this is what we're talking about today. All right? So you get the concept, you get the idea, very important, because I'm trying to give you some basic knowledge. Why? Because I want to be able to dialogue this title tonight. And the only way I'm going to do that, I have to give you some basic ideas of what's going on. All right? Again, a lot of us have faced this criteria, which is the judicial system, under family law, traffic law, criminal, civil, bracket C. That's just a few. There's others, small claims court. So whatever you have been subject to, you will fall in one of those categories. If you haven't, you're really fortunate not to, but it doesn't say eventually you won't. It all depends on your circumstances. Like if you own a house and you got a mortgage, as an example, and you've run into some financial difficulty, they're gonna take you into some superior court or court of common pleas, and they're gonna wanna do what? Foreclose on your property, all right? So how can you develop what you call is a juridical argument, a judicial defense against connotative incarceration, which means, give you an example. When they take your name and put it into a title caption, right? And say Jim and J and Associates versus John Doe, say that's your husband, for the sisters, Jane Doe, that's your wife, brothers, right? And then, of course, you have your index number, just giving you an idea, or your docket number, or your case number, as they call it, right? And then there's say, right here, just give you an example. Foreclosure action, as an example, all right? So now you're in the foreclosure part of that court, dealing with this particular mortgage company, J and Associates versus John Doe and Jane Doe. So now, how do your name wind up being put into that caption? Because your name being put into this particular action to foreclose on your property, right? That will be considered to be called connotative what? Incarceration. Because now you are incarcerated into a particular contract with the court to answer to the mortgage company based upon a mortgage contract that you entered into, all right? Not knowing that the mortgage contract has some indemnification clause in there that will protect you from your house being foreclosed on. So how would you recognize that if you don't have the juridical linguistics against connotative incarceration? So I'm just trying to give you some idea that you can defend yourself, right? But you have to learn the juridical language, right, to protect yourself in writing, which is they call motions, or they may call it pleadings, right? Or you may have to give an oral argument. Oral argument, all right? So one has to begin to start learning the juridical linguistics or language so you can incorporate that into the motion pleading or into your oral argument, because the attorney is going to come with a language that can be vilifying and degrading to your character or to your good name, all right? Because your name has credit to it. Because when you first got into the contract, and it don't make a difference if it's a student loan, I don't want people to be stuck. I don't want you to think that I'm just talking about mortgages. It could be a student loan, it could be a traffic ticket, all right? It could be a mortgage, it could be an auto loan, it could be any of these particular instruments that you sign your name to, these contracts, all right? And the contracts that you sign your name to, you didn't know that is uncontrollable. Uncontrollable means the terms and conditions was not transparent. Transparent where you would actually know what they're talking about. Because if you knew what they were talking about, you would question the content of the contract. You would not sign your name to a contract that's going to incarcerate you prematurely, right, before you get to court. Because one of the things that the judge would say, counsel, do you have standing? And standing can be where they can send you notices in the mail as an administrative process that one have to answer, which is very, very important. Because if you receive anything in the mail from any creditor, I have to begin to start showing you the references and show you the content and form and the laws where you can go to defend yourself even before you go to court. Or I can put you in a position where you don't even have to go to court. All right? Because some people are so fearful of court, they don't know what the judge is going to say, they don't know what the lawyers is going to say, it's a fear factor, you don't know if they're going to freeze your bank account, take your house, take your car, you know what I'm saying? So all these things play an intimidating role on your psyche. All right? And once this thing infatuates you, then you begin to start acting emotionally. And then we don't know what to do. So this is the reason why this lecture is so important, so that way we can show how you can use proper juridical defenses. All right? We're going to have a class next week. I'm going to, of course, print out some stuff for you next week for you to have, so that way you can get an idea. Because tonight is sort of like an overview. All right? That's what it is, where we can just dialogue, see what people's situations are, give you examples so you can see how you can defend yourself. And then next week, I can give you some sources of information that you can go and look for. Earlier, there was an announcement sometime, I think what you said in January?
January.
Yeah, we know about January.
Yes, in reference to Jenkins Law Library. Because it's very imperative for all of you who are here, come to this seminar that we're gonna have, because me and Abdullah had did this, what is it, 09 or 10? 10. And we taught in not only Jenkins Law Library, but we also taught in Rutgers. All right, and what I did, right, or what me and Abdullah did together, I should say, as a team, is that I started to cite the books, the case laws. The numbers on the binder is the number of the book, and then you have the page, all right? And then you have the parties. And then what we was doing was going into the points of law that one can see, that one can use, all right? Next week, I'm gonna bring a memorandum and order from a judge, something that I did. My brother, who was supposed to have been here tonight, apparently he didn't make it. But it was a situation with his car. Nissan was making claims against his car, and when we brought him to court, the lawyers knew they was gonna lose in state court, so they did a removal and brought it to federal court. But I'm gonna bring that memorandum next week. I'm gonna read some of it, and I'm gonna show you something, because one of the things that people don't grasp, that even a case that looks like it's losing is a winning case. So I'm gonna show you that concept also. But again, I wanna get back to this issue concerning the juridical linguistics against connotative incarceration. Give you an example. Superior Court, J and Associates versus Jane Doe. When a company or a lawyer put your name into a summons and complaint, which I don't know if you're familiar with it, but I'll write it down. A summons and complaint. All right. The summons is a writ that orders you to come to court and answer to a complaint. And you don't have to really come to court at that particular moment, but they want you to at least answer the complaint. That you can come to court and put in what you call is an appearance on the record, right? That's the way to cure the summons so you won't fall into default. And then you would have to answer to the complaint. You would have to put in what you call as an answer, affirmative defenses. Are you taking notes?
Yeah.
Very important. and a counterclaim. All right, this is the three body that you need to recognize when it comes to this complaint. People would say to me, well, how can I answer it? You know, what can I do, or what sources or references of information can I answer that complaint? Depending on what your complaint is drafted upon, all right? It can be issue concerning a civil, like a small claims, or it can be a foreclosure, as we wrote over there, right? Depending on what the complaint is. Now, what I'm saying is this. Say for instance, let's use the foreclosure as an example. Let's use the foreclosure as an example. The foreclosure has a complaint being written up by an attorney, all right? Now, the attorney is going to be what you call alleging. Listen now, if you have any questions, please stop me, ask me questions, because I want to make sure that everybody is on the same page. The attorney can be alleging issues in the complaint concerning the mortgage. As an example, right? Now, he may say, this is what he may say as an example, because we learn from examples. He may say in the complaint that the defendant executed and delivered the mortgage and the note to the lender on this particular day. All right, this is what he would say. All right, now, say for instance, we throw out a date out there. We throw a date out there. Give me an example. Say for instance, let's say October 2005. All right? This is what the attorney is alleging in the complaint, that the lender gave you that mortgage in October 2005, but you had the property since, say, October 2000. So that means you had the property 5 years prior to you getting a mortgage, right? So did you acquire this property in 2005, or did you acquire the property in 2000?
2000.
All right. If you're not with me, please raise your hand and talk to me, because I don't know if you're with me. Because I don't want to be talking and not getting to the point. 2000 is when you, no, acquired, which is true, you can say purchase. The property, acquired the title, all right, to the property. You did it in 2000, but you got a mortgage on the property in 2005. Now, if the lawyer says in the complaint that the lender gave you the mortgage in 2005, right? That you own that property prior to you getting the mortgage on it, correct?
Yes.
Because you acquired it in 2000. All right? So what I'm showing you here tonight, this will be what you call is a juridical defense. That's the linguistics that you're going to use in your pleading against the connotative incarceration, because what the lawyer is trying to do is trying to make this the issue. But you owned it here. So this takes precedent over this. So he's going to make it look like as though you purchased the property in 2005 when you really acquired it in 2000. Why? Because you had equity here. This is where your equity was at. What you do is what you did is you pledged your equity into a mortgage. All right? Because you needed the money for the loan. You follow me? For whatever it is, student loan, buying a car, maybe another house. You get what I'm saying? So I'm giving you the insight to see that an attorney, and they do this all over the country. This is not something that I'm saying in New York or Pennsylvania. They're doing it all across the country. If you look at a complaint for a mortgage and you look at the paragraphs or the language, you'll say, oh, I see what the brother's saying. Wow, it's a pattern. All right? That's why I always ask a person, when did you first acquire your property? Because what happens is that if they're going to talk about the mortgage, what you're doing is allowing the attorney to steal your equity. If you had the property 5 years prior to you getting the mortgage, that was your equity that you pledged. That belongs to you. You have a right of redemption to your equity. All right? You have a right to the redemption to your equity. You have a right to the redemption of your equity even in the student loan. A lot of people don't realize that. You say, student loan, how could you have equity in student loan? You got credit. You had to have credit to get the student loan.
Right.
All right? You have to have credit for the student loan. Credit can be turned into what?
Cash.
Cash. I just want you to see this stuff. Because you'll need to know this language in order to implicate juridical defense, all right, against incarceration, all right? Because they're going to connotate the language in these pleadings to incarcerate you, and they're going to make you look like if though you're incompetent, you didn't meet your obligation. You know, they're going to come up with all kinds of variables to degrade your character in equity or in finance, all right? This is what happens when it comes to these contracts. I don't care if it's a student loan, mortgage loan, auto loan. This is the protocol that these attorneys do. They attack you. All right? They would linguistically attack you. They would incarcerate you and make disparaging statements within the complaint to make it look like as though you're not meeting your obligation. All right? So credit can be turned into crash. So if credit can turn into cash, that is considered to be your what?
Equity.
Equity.
Y'all need to know that. Y'all need to know that. So not that this applies to a mortgage, but it also applies to a student loan, an auto loan, whatever loan that you have taken, because you gotta remember something. It's your signature,
That makes the money.
right, that they need to acquire the credit on contract. This is what they need. They need your signature. Because your signature becomes what? An agreement. They don't need that to become an agreement, but it also becomes
Assignment.
an assignment. Because you can see the word sign in there. You follow me? You can see the word sign in the word assignment. Your signature becomes an assignment to any contract. All right? I don't care if it's a mortgage contract, student loan contract, credit cards, or you know what I'm saying? So I'm just trying to give you the idea that it's the same basic principle. All right? The same basic principle, so that way when it's time for you to insert your juridical linguistics when it comes to your motion pleadings or your oral argument, you would know the language so you can defend your equity. Because basically what they're going after is your equity. Yes, Abdul.
Can you explain assignment?
Oh, thank you, Abdullah. This is what I'm saying. You see what Abdullah just did? Because you're gonna make me think that y'all know what I'm talking about. So please, feel free. An assignment is a transfer, right? It's a transfer of your equity. That's what's going on. That's why you hear me talking about the equity so much. Because the equity is your money.
So one question that I have, so that is what happens, I got some kind of problem now that I put this into my practical life.
Yes.
The thing is that I do sign a contract, example that I want to acquire a
Yes.
service.
Yes.
I acquired a service, and one of the things that I am doing right now is
Take your time.
I lose my question.
All right.
What I
You signed the contract.
No, I signed a contract, and my question is, so I did sign a contract. What are they doing as soon as I put my signature
on
and
the
they're
contract.
based on the contract?
All right.
They allowed to pass that contract and to do business with that contract
You see what you just
to
said?
the
Beautiful, brother.
To
Would you
the
just-
other,
Party, to
example
the other
for
party, to the third party.
the
That's
debt
correct.
collectors example.
No, not even the debt collectors. You don't even say debt collectors. I hear what you're saying. The debt collectors only come in play is when you default on the contract.
Yeah.
Because now they know that it's worth a lot of money because they can buy it at a discount price. You see what I'm saying? And get the full price from it. You know, the person who they're buying it from, they can get it at a discount price and they go after you for the full price.
For the full price.
That's what the debt collectors do. So that's another part of it. But what you're talking about is when you sign your signature onto a contract, and then what they do is they sell, assign, right, and transfer.
Transfer.
Because when you use this word assignment, there's 3 words here that you'll need to know. It's called sell, assign, and transfer. Those are the 3 concepts to an assignment, which means what are they doing to your signature? Because the word sign is in the middle of the word assignment. So if you see the word sign, they're referring to your signature. So what are they doing with your signature again? They're assigning it,
Assign it.
all right? They're selling it,
Or transferring.
transferring it, right? Transfer, sell, and assign, all right?
Right.
Which means, and that's what makes it an assignment. Those 3 concepts is what makes it an assignment. You follow what I'm saying? And this is to any contract.
To any, even for a rental.
It doesn't, yes,
That applies to verbal.
yes, that applies to verbal too.
Just so.
Yes, that applies to verbal too, because they got verbal contracts, oral contracts, this is like written
It's still
contract.
written contract.
But it applies to
Still-
leases too. You know why it applies to leases? And that's a good point. It's because, say for instance, a new owner decides to buy the building. He's buying all the leases.
Yeah.
You follow me? So now all those leases become an assignment to the new buyer. To the new buyer. All right, now the seller used that as a leverage to get the money that he wants for that building. You see what I'm saying?
Mhm.
He uses those leases, those rents and those leases, that becomes an assignment. He bundles those together and he can get what he wants because he knows that all those leases are worth money. Just like in car dealership, all those leases are worth money. They can bundle those things and they can sell it to investors. You see what I'm saying?
Yeah.
So remember, the 3 concepts is sell, assign, and transfer. That's the concepts. Those are the 3 concepts to an assignment. Yes.
What makes the signature so powerful? Because I'm thinking while you were just talking over with him, getting like how credit is cash. Let's just say a student newly going into college doesn't have any quote unquote credit, but they want to give them the credit card. So
Excellent question. See, that's what I said. You gotta talk to me, y'all. Because if you really want to know this stuff, you get the best out of me if you talk to me. But I can keep talking about this concept. I'm not sure if you're getting it or not. That's why I say, are you with me? If you hear me saying I'm with you, with me, you'll be. You know what I'm saying? Or you'll make me popcorn like, yeah, he's really putting it in.
Without the hot dogs.
Yes, without the hot dogs. Your signature becomes an obligation, and they can sell it. So you made a very good point when you said, what is it about the signature? It becomes an obligation or a commitment, all right? And they need your credit for that. Because they're not just taking your signature as an obligation, but 9 to 10, your credit is involved. So each one of us here is rated, and you're worth whatever your credit is. How you can tell what you're worth, what your credit is? If you try to get a bond, the first thing they're gonna say is, what is your credit?
right.
That's the first thing they're gonna ask you. If you try to get a bond, they're gonna say, well, what is your credit? You know what I'm saying? If depending on what your credit is gonna determine the value of your bond. All right? You're with me?
Yes.
Yes.
All right, this is very important information. This is all a part of juridical linguistics because what happens is that once you begin to start recognizing the language, then you know how to speak or read or write it to defend yourself against those who try to incarcerate you and try to make it seem like as though you breach your obligation. All right? All right? Another juridical defense that you can talk about, which is very important, right, is insurance. Very important. Why? Because, say for instance, you have mortgage insurance. Listen to me carefully. I'm about to share something with you that's very important that you need to know. There's a mortgage insurance clause in your mortgage. the banks and the lenders would not give you a mortgage without it being what?
Sure.
Insured. So now listen to this now. There's a clause that specifically says in the mortgage, it says that mortgage insurance means, mortgage insurance means lender protected on non-payment or default on loan. That's what it means. So if lender is protected on non-payment or default on loan, what is that telling you?
That if you don't pay, that they're already
He receives
paid.
the money.
There's insurance, that's
It's
right.
already insured.
There's insurance there. So now, if there's insurance to pay the default or the non-payment of loan, right, if you fall into financial hardship, should that mortgage or that loan be foreclosed on?
No, because it should already be paid.
The insurance would
Insurance
cover
cover
it.
it.
So that's, so this is how I know that it's fraud closure. As instead of foreclosure, it's fraud closure. Because if the mortgage is insured, why would they want to foreclose it if it's insured? All those loans are insured. Student loans are insured because people would say, oh, I got a student loan for $50,000, $60,000 and I can't bankrupt it because in bankruptcy court, they wouldn't allow me to bankrupt the student loan. I said, but the student loan has insurance. Nobody ever raised the student loan that's the insurance on the student loan. So the student loan has been indemnified or insured. So now what you got to do is find out what's this insurance on that student loan.